All right, hi, and welcome back. Attorney Steve Vondran here. We are talking about the Twitter and the president. Can the president block a Twitter user that he doesn't like? Okay, so this is a new case that just came down, so I thought I'd go over it with you. This is the, what do we call this? The Knight First Amendment Institute at Columbia University versus Trump. So this is a First Amendment organization taking on Trump. This is general legal information only and not legal advice. So let's get into our PACER system here, okay? So we're in PACER. I looked the case up here, and first place I always go is the attorneys. I want to see who's involved. Here's your First Amendment Institute. That's the plaintiff bringing this action. So what happened is a guy went on to the at Real Donald Trump Twitter site, and I think Trump had sort of always had that before, even when he was running in his campaign. And so that had always been considered like his private Twitter account. And then when he became president, you get your presidential POTUS account. But I think he maintained his Real Donald Trump account because he wants to keep it going. So I think he sort of treats it as a private account. And somebody went on to at Real Donald Trump, said something criticizing his policies, and they blocked him. And so a lawsuit was brought basically saying, can you block somebody from coming onto the Twitter's presidential account, whether it's private or public, who knows? And that was what this case was about. So this was brought by the plaintiff, Knight First Amendment Institute at Columbia. Here's a bunch of, looks like attorneys, or maybe these were some of the plaintiffs that had posted some comments and were kicked off, maybe one or more. I haven't read the case. But here's some firms in. We have another firm representing them. U.S. Department of Justice, the Civil Division is involved over here. Now they're representing a defendant. So there's lots of parties. Amici curiae, I believe is how you pronounce that. Those are amicus brief, what we call friends of the court, where you're basically sending something into the judge and you're saying, before you make a decision, think about this. Here's some implications you may not be aware of. So you have some amicus briefs being filed in here. Here's another amicus brief by the Institute for Constitutional Advocacy and Protection. U.S. Department of Justice is in here. So, I mean, this was like a big case. American Civil Liberties Union, ACLU. They've got some plaintiffs. So as you can see, this was a really big case. So I just wanted to point that out. So the real issue was, can you block a person that's commenting on the Trump's account? Now, the end of the story was basically the judge said no. This is, number one, it's a public forum. It's like a virtual town square. And so, Trump's lawyers tried to argue that, well, wait a second, I have a First Amendment right of association. I can decide who I want to associate with and who I don't. And the court kind of overlooked that and said, no, yeah, there is a right of association, but this is a public forum. People are coming in with political speech. As we've talked about on my First Amendment video, how to dazzle your friends with the First Amendment, political speech is going to be the highest form of protected free speech there is. I mean, it's literally the highest. We want people to be able to come and give their comments and ideas, good or bad, whether you like them or not, but in these traditional public forums. So the court said that this was basically a public forum, like I said, a modern day virtual town square. Court also talked about this not being, and I'm trying to get this up here for you if we can find, let me see if I can find, sometimes you can get these orders, number 72 might be the order you're looking for. I should have had that up for you, so apologize. But yeah, here it is, and I'll just scroll through. There's 75 pages, so you're going to have to come in and want to get it. But at any rate, the court said this was not a personal account, even though it seemed like a personal Twitter account at Real Donald Trump. They said the reasons why it's not is the account was registered to Donald J. Trump, 45th President of the United States. So he used his own language there, sort of making it a government type of site. The account tweets are official records that must be preserved under the Presidential Records Act. So that was interesting because their records are essentially public records, and you got to let people comment. And the account has been used in the course of appointing and removing officers. Another reason, and also conducting foreign policy. As you know, Trump likes to do some tweeting and commenting, and it drives everybody crazy when he's doing things with, little Kim, little John Kim, and other people. So because of these reasons, these factors, the court said this is a public area, and speech that attacks, viewpoints, as we call it, viewpoints, is subject to strict scrutiny. If you remember that word, if you're preparing for the bar exam, this is important. It's coming up for sure, no question. Strict scrutiny, laws that regulate viewpoint, that are not viewpoint neutral, they have to be narrowly tailored and subject to a compelling government interest for doing that. Okay, narrowly tailor, no lesser means available, and compelling government purpose. So that was really what the case was about. The court said there's strict scrutiny. There's no reason to kick a Twitter follower off just because he doesn't agree. That's not good enough. That's not going to satisfy the strict scrutiny standard. The court awarded default judgment. It looks like probably on motion for summary judgment. And you can go through and read all that if you want. You can set up, if you like law, you should set up a Pacer account. You can get these opinions on there. And it's kind of fun to read exactly what's going on. But that's a nutshell. So again, public officers, public figures, public officials, if you're your local senator, congressman, your U.S. senators, they're using these sites in those manners. Those are probably going to be deemed town squares. People have a First Amendment right to come in, engage, comment, and they shouldn't be blocked. Or they may be able to do what the plaintiffs did here, is come and say, Judge, they can't block me. I don't care about their First Amendment right of association. I want to post a comment on Mr. Trump's webpage. So I hope that's been an interesting case for you. I thought it was interesting, so I thought I'd share it. But now I got to get back to work. And we'll see y'all again. If you like this video, give me a thumbs up, comment. If you didn't like it, tell me why it was horrible. Feel free to subscribe and help us reach our goal of 10,000 subscribers. We're getting close. We need your help. We appreciate you following us. Okay? Thanks a lot, Attorney Steve Vondran. I got to go. We'll see you later.